Nebraska has a lightly regulated breaking lease framework with a statutory duty to mitigate and one of the strongest anti-retaliation protections in the country. The governing law is found in the Nebraska Uniform Residential Landlord and Tenant Act, Nebraska Revised Statutes. Chapter 76, Article 14, along with General Contract Principles. If you're a landlord or tenant in Nebraska, the state provides basic statutory clarity while placing the lease agreement at the center of the early termination process. Let's start with the landlord's duty to mitigate damages. Under Nebraska Revised Statutes, Section 76.32, when a tenant abandons the property or breaks the lease, the landlord has a duty to make reasonable efforts to re-rent the unit. Nebraska's mitigation requirement is statutory, providing clear enforceability. The landlord must take reasonable steps to find a replacement tenant, advertising, showing, and accepting qualified applicants. The departing tenant's liability is limited to rent during the vacancy period plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable mitigation. Early termination clauses are generally enforceable in Nebraska. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. The fee must be reasonable. Grossly excessive fees could be challenged under general contract principles. Military members have the right to break a lease under the SCRA. Offutt Air Force Base, home of U.S. Strategic Command, generates significant military rental demand in Bellevue and South Omaha. SCRA terminations are regular occurrences. Nebraska does not have a specific state statute providing enhanced lease-breaking protections for domestic violence victims. Victims must rely on general contract principles or negotiate with the landlord. Tenants may break a lease if the landlord fails to maintain habitable conditions. Under Section 76-1419, the landlord has a duty to maintain the premises in a fit and habitable condition. If the landlord fails to act after receiving written notice, the tenant has remedies including lease termination. The tenant must provide written notice and allow 14 days for non-emergency repairs before terminating. Nebraska's one-year anti-retaliation presumption, the longest in the country, is relevant to the breaking lease context. Under Section 76-1439, if a tenant exercises any legal right, including making habitability complaints, and the landlord takes adverse action within 1 year, retaliation is presumed. This means landlords who pursue aggressive damage claims against tenants who terminated based on legitimate habitability issues face significant risk. From a practical standpoint, Nebraska's rental market is concentrated in Omaha and Lincoln. Omaha has a competitive market driven by financial services, healthcare, and Offutt AFB. Re-rental is typically moderate at 2 to 4 weeks. Lincoln, home to the University of Nebraska and state government, has a strong market with student-driven seasonal dynamics. Smaller communities have more limited markets. One best practice: include a clear early termination clause in your lease. Nebraska's statutory framework provides a foundation, but the lease is where you define the specific process. Another best practice: document your mitigation efforts thoroughly. Keep records of every step: listing dates, advertising, showings, and when you accepted a replacement. Nebraska requires landlords to return the security deposit within 14 days, one of the shorter periods in the country. The deposit is limited to 1 month's rent, or 1.5 months with a pet. These rules apply to broken leases and normal move-outs alike. For the complete guide to Nebraska breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.